Okay, we're now recording, and let's start talking about the quiz. So this was the quiz that I have assigned for you guys. As you know, it's not due until Wednesday. I see that most of you have submitted the week 1 quiz, so I haven't graded those yet, but I will. And let's make sure we understand all these 5 questions on week 2, so that's easy for you to do. So number 1, what does it mean to say that an act is wrong because it's wrong? Can you give an example of something that's wrong because it's wrong and something that's right because it's right? Who can answer this?
Can I answer?
Yeah, sure.
I think here we're talking about the malum per se and the another kind of malum that I forget now. Malum per se and malum prohibitum.
Prohibited,
Yeah. And malum per se is something that's wrong because it's wrong, like, I don't know, kill somebody, burn somebody's house, and so on. And malum prohibitum is something that's it's something wrong because it's in the law. I mean, it's because of the government rules, like, I don't know.
Okay, but that's not what this question says. So we need to be very clear in law. I don't need you to lecture me on what malum prohibitum is. That's not what this question asks. I will not give you points for answering something that's not my question.
Okay.
I mean, you all have my PPTs. It's not hard for you to tell me a page of information. You know, the question was, what's something that's wrong because it's wrong? So, okay, you said that's malum in se, but you didn't explain it. You know, what does it mean to say something is wrong because it's wrong? Yes, that's called malum in se. That's the name for that. What does, that's not the answer though. What does that mean?
It means like for some reasons can be God, or can be like to the wealth of the society. We must not do these things.
That sounds, when you say we must not for society, you're almost describing prohibitum. The government says you must not do some things for society. You must not drive through the light when the light is red for society. I mean, you're literally describing the other kind. Can somebody else try to join and help us? Florian, tell us, what does it mean to say something is wrong because it's wrong?
Yes, is according to the natural law, which is the notion of malice, which means like when you do something premeditate, like you do it on purpose, which is naturally wrong, which is naturally...
Why? Why is it naturally wrong? Who says? You say? Are you in charge of what's right and wrong?
It's like evil act, kill someone. This is evil. Against nature.
What do you mean? I mean, in law, we have to be able to explain ourselves. You can't just say it's evil. There are lots of cultures throughout the world that have said some things are good and some things are evil. And we can't just say that without explanation.
Because it's against the moral.
Okay. It's against morality. It's ethically wrong. I mean, I would expect that you guys do a little bit of work, you know, to try to figure this out. What does it mean that something's wrong because it's wrong? You know, this is it's a question that you actually have to think about.
Because it's against the like in the natural law, what I read, it was like it's against the human natural right. It's like I go against the nature right.
Okay.
That people.
Okay. I'll accept an argument about natural rights. Crystal, can you tell me something that's right because it's right?
I think it's about like donation, respect people, or taking good care of your family, because you are actually benefit the society, do something that will benefit the society.
So it's right to take care of your family?
Yes, like it's an obligation to do it.
So you're saying it's right because it's an obligation to
it's
society.
Yeah, definitely the intention is to benefit someone else. It's recommended to do, but maybe it's not necessary, but it's recommended to do. It's a good thing to do.
Harry, can you tell me something else that's right because it's right?
Well, I think someone mentioned like killing someone is wrong. So I think punishing them would be right, the right thing to do.
So it's naturally right to punish people?
I think it's just universally accepted that this is just right.
But you're saying if someone does something wrong, they should be punished. I'm
Yeah.
not talking about doing something wrong. I'm talking about something that's naturally right. It's something all humans should do. Like all humans should not kill. All humans should what?
I haven't got an example of that.
Florian? Your sound is off.
Has the right to live.
Okay. The right to life is considered to be a natural right. That's the opposite of killing someone.
Yes, exactly.
It's right to live. That's right. Everybody has the right to live. Amar, is there anything else you think everybody has the right to do?
Well, freedom of speech.
You
about
sound
that?
like you're asking me, but okay, maybe.
Yeah.
Maybe freedom of speech is a natural right. Aruni, do you think everybody has the right to say, express themselves?
Yes.
Okay, so maybe we do think freedom of speech. Jody, is there anything else you'd say is a natural right? Everybody should have the right to what?
I don't know, sir. No idea.
Okay, Tiffany, anything come to mind?
I think everything everyone said is pretty much right when it comes to speciesism. Humans are social creatures, so we would want to help each other, give life, not kill each other, but it's okay to kill other animals for food and things like that. So yeah, it's right because that's in the nature of our animal instincts.
Do you think everybody has the right to eat if they're hungry?
Yes.
But we don't live in a world where that's true.
No.
So that's an interesting question because there are some things that are possibly natural rights that all humans should have the right to do, and we do not, as humans, all have the right to do this. Does the law protect your right to eat if you're hungry? No,
Does
quite
the
the
law-
opposite. The law will protect my right to keep my food and let you starve.
Yeah. It's a lot of people.
Okay, number two. How about Junpyo? Which of the two elements of the rule of law is more significant in your opinion and why?
I'm not sure, but is it about can I pass this question because I'm not pretty sure.
You did not review your PPT.
Can
How
I
about
answer this?
Min? Min, can you tell us? Min, are you there? Your camera's off.
Can I answer this?
Well, just a minute. I think Min is
Okay.
not here.
Okay.
No Min. Okay.
Okay,
Yeah.
the difference between this public law and private law.
No, number two. Which of the
Number
two
two.
elements of the rule of law is more significant? Florian.
Oh, yeah, I jumped to number three.
I choose accountability, and because in my opinion, when you set a law, you must also explain what are the responsibility and all of the detail, and then justice about the law. Each law has to be released and have a notion of justice. If one law is unjust or against natural right, I think this law should not be.
I'm sorry. I'm not sure where you're going with this. There are two elements of the rule of law, right?
Four.
There's equality, and there's no arbitrary and prerogative rules. That's it. That's the rule of law. It doesn't need a long explanation. I just want to know which one. Equality or no arbitrary and prerogative rules.
I go for equality.
Why?
Because we should all be this equal front of the law and front of the judge.
Okay. Does anybody else disagree? Ooh, I don't like this. I don't like that nobody's doing the work. If this happens one more time, we're going to stop reviewing the quizzes.
I disagree.
Yeah, Tiffany.
I disagree.
Was that Tiffany who said that?
Yes.
Okay. Why do you disagree?
Because I think the arbitration
arbitrary.
Arbitrary and the prerogatory elements of law is often overlooked, even if there is equality in place. As far as I'm exposed to when it comes to law.
Not sure I understand your answer.
It's because when it comes to the famous court cases that I have been informed of, such as like O.J. Simpson, or like the court cases of the
okay, I'm sorry.
The companies.
This isn't clear to me. This isn't clear to me.
Sorry.
So it's okay, but look, everybody, we're now 20 minutes into class. This is not a good use of our class time. So from in the future, the quizzes are going to be due before class, and we will review them together. But obviously, it sounds like if I let you guys not do the quiz, nobody's going to even look at it. So that's that. Okay. I need you to answer these questions and explain them. Which of the two elements is more significant? This is not beneficial for me to just tell it to you because you're not doing it. So this is due on Wednesday. So discuss those two elements. Equity, explain a situation where a court might give an injunction and where it might give specific performance. We went over that last week. Does anybody have a question on that? Do you know what is an injunction? What is specific performance?
Injunction is when you want to stop someone to doing something.
Good.
And specific performance is for unique items where you require the other party to perform the contract.
Good. Carlotta, are you there?
Yes.
Are you there?
Yes. Can you hear me?
Your camera is off. Are you in a haunted house or something?
No, it's just, I just woke up. Sorry.
We're in class. Okay, please don't sleep through class. I will not give you credit for being here if you sleep through class. Carlotta, tell me something about factor tame.
I didn't read this one.
Okay. Okay, the quiz is due on Wednesday. If I see you guys are actually doing the work, then I'll go back to discussing it before it's due, but now that is over. It will be due before we discuss it. The homework I gave you was to discuss Donoghue and CAPARO v. DICKMAN. So we did a little bit about Donoghue last week. We can talk about torts for a little while now. Let's get back into torts. And then after that, we'll talk a little about the midterm. So where did we stop last week? Torts 1, page 1 to 4. Okay. Let me share that. Okay, last week we stopped right here, where I said, these are the important things you need to know about torts. And I said, we're gonna start this week by talking about negligence. That's really the biggest one that you need to know. Okay, so what is a tort? Crystal, what's the definition of a tort?
Tort is a civil wrong.
Good. It's a civil wrong. And what does that mean?
That means if you did something wrong, the punishment is not send you to jail, but for monetary compensations.
Good. Good. So a tort is a civil wrong. It's a legal case, and you did something wrong. But the difference between a tort and a crime is with a tort, the punishment is money. Ooh, I can do a highlighter. Can I? Yeah, the punishment is money. Okay, good. So yeah, so it's a civil wrong. It's court case, and the punishment is money. It could be injunctions. It could be specific performance, but nobody is going to jail. And that's pretty much what we've learned so far. The next thing to say is about this idea of negligence. So there are many, many torts. And we looked at some of them before. We looked at assault and battery and false imprisonment, loss of consortium, intentional infliction of emotional distress. We looked at a bunch of different torts. Negligence is an example of another tort. And negligence is a very important tort. That's one that we use in business the most, because negligence is a case where someone was not careful and you got hurt. Now, I said before, when I say you got hurt, there are 3 ways to be hurt. Anybody remember? Just unmute and tell me, what are the 3 ways you can be hurt?
Emotionally, physically, and financially.
Good. Emotionally, physically, financially. These are the 3 ways you can be hurt. Now, if somebody hurts you financially, that's negligence. So that means that, let's say I make a business deal with Amar and I get some boxes of men's shirts from his factory, and I open up the box and the shirts are the wrong color. He's hurt me. Financially, he's hurt me. Now, could I sue Amar for a breach of contract? Yes, I could, assuming that we have a contract. I could, sure, but that's one kind of court case, and that might not be very easy to win. What if I don't have a clear contract with Amar? Sometimes contracts aren't all that clear. In that case, you might want to use negligence. So with negligence, we have this idea of duty of care. We have this idea of duty of care that we talked about last class, that we said, you know, does a doctor have a responsibility to tell either the school or a student's parents if it looks like the student might be in danger, right? So we talked about that idea. Did you guys watch these videos? I don't want to have to go through every single slide. Yes?
Yeah, I did.
Okay, wait a minute. Raise your hand if you watched these videos on torts. Okay, so almost nobody. Okay. Okay, just gotta know where we stand. Okay, so you're gonna have to know this stuff because our midterm, which we'll talk about in a little bit today, is all about torts and it's all about negligence. So I'm gonna move through this pretty fast because the reason that there's hours of videos is not because it's fun for me to make videos, but because I need you guys to watch them because I don't have time in this class to go through everything. So with negligence, there are 3 parts. The first part is called duty of care. And duty of care says, this person who hurt me, do they have a responsibility to me? Not everybody has a responsibility to each other. And so, for example, do you guys have a responsibility to each other? Does Crystal have a responsibility to Carlotta? No. You're just two classmates, your peers, your equals. You don't have any sort of relationship that would give you a responsibility. Do I have a responsibility to you? What if I don't teach you all of this stuff? I don't teach you any of this stuff. I think it's boring. So instead, I teach you about family law. We spend the whole semester talking about divorces. And then Carlotta, you take the test and you fail. Could you sue me for that?
Yes, because
Sure.
there's a financial.
Sure, because you'd have to take the test, you take the class again, and that would cost you money. So I have a responsibility to you guys. I have a responsibility to teach you the correct material, follow the syllabus, follow a sort of textbook. I have that responsibility. And that's the first question. And to answer this question, does someone have responsibility? We have tests, which we're going to look at in a minute. We have, for duty of care, we have 4 different tests to see, does someone have a responsibility? It's not a yes or no question. Then the question is, okay, David has a responsibility. Did David break? Breach means break. Did David break his responsibility? And we also have 4 tests. And then the final question, okay, David broke his responsibility, but did I get hurt? Did you get hurt even though I broke my responsibility? And that has 3 tests. So in your midterm, you're going to have to really understand these 11 tests. They're all quite important. So when we say test, what do I mean by a test? Well, let's start talking about duty of care and the tests there. And we started by duty of care by talking about this case of Donoghue v. Stevenson. So we talked about Donoghue v. Stevenson a little bit last week, right? So Jordan, can you tell me, just remind me, what's this case about?
This case about 2 women. They went to the, how to say, they went to the cafe, bar or something, and they bought ginger beer. And then the one she found in this bottle is snail, pieces of a snail inside, and later she sued the owner of the cafe. That's according.
Okay, but you're kind of telling me the story.
Yeah.
You're not really telling me the law. Can anybody tell me what's this case really about?
It's about negligence, right?
Yeah, sort of. Can anybody tell me what's the issue here?
The first issue was like the lady that purchased the ginger beer was not the same of the drink one. So we have a contract problem in the first place. Like so she cannot sue the cafe owner. So firstly she might like, who can I sue? So she sued the ginger beer manufacturer. It was the very first thing.
Okay, so you're on the right track. I think we can say this more clearly. I'd say the issue is, can you sue someone if you use their product but you didn't buy it?
Yeah.
That's really, just a minute, Florian. That's really the question. Can you sue someone if you use their product but you did not buy their product? That's the question here.
Yeah, you can sue them.
What's the answer? Can you?
Is how it's affected by neighbor, something that the manufacturer do and affecting the neighbor.
Okay, so we did get from here this Lord Atkins neighbor test. Now, what I need you to know about this neighbor test is 3 or 4 words, really actually 2 words. Here's what I need you to know: direct effect. That's what I need you to know about the neighbor test, these 2 words. This is on your midterm. Okay, this is what you're writing your essay about. So direct effect. This woman, Miss Donoghue, who's drinking this ginger beer, Tiffany, was she directly affected by the manufacturer of the beer?
Hi. Yes.
Yes. Hi. Was Miss Donahue, are you away from your computer? I'll ask someone else. Aruni. Aruni, tell me.
No, that's not fair.
Okay, you're muted now. Let me just ask Aruni. Aruni, unmute. Was this woman, Miss Donahue, who drank this beer, directly affected by the manufacturer of the beer?
Not directly, because she was drinking in a cafe.
Did she get sick?
Yeah,
Why did she get sick?
from the dead snail.
Who put the dead snail in there?
It's either the manufacturer or someone from the cafe.
This was a closed bottle, like a bottle of beer that's closed. The cafe just bought a big case of these bottles. They didn't open them. I mean, this is like if you go to a cafe and you order a can of Diet Coke or a can of Coke. If you open it and there's something bad in the Coke, the cafe didn't put it there. They never opened it. This was a closed, sealed bottle. So whose responsibility was that snail? Who allowed the snail to get in there?
The manufacturer.
So was Miss Donahue directly affected by the manufacturer's actions?
Yes.
If the manufacturer was careful, would this have happened?
No. No.
Does the manufacturer, Aruni, in your opinion, does the manufacturer have a legal responsibility to make sure that their customers don't get sick?
Yes.
Sure. But do they have a legal responsibility to make sure that anyone who drinks their drink doesn't get sick? Or do you think they're only responsible to their customers?
I think they're only responsible for their customers.
So let's say I make a kind of food, okay? I make bubble gum. And Aruni, you buy some of my gum and you give a piece to Jody. Jody's your friend. He says, hey, do you have any gum? You give him a piece. Jody, you eat it, and there was poison in my gum, and Jody dies. Would you say I'm not responsible at all? It doesn't matter that Jody died. I'm not responsible, even though my gum was poisoned.
You are responsible.
Because it doesn't matter that Jody didn't pay me. Someone paid me. You paid me. It really doesn't matter how Jody got my gum. I put it out there in the world. And by manufacturing something and putting it out there in the world, I have a legal responsibility that it needs to be safe. Aruni, do you want to live in a world where manufacturers can put out dangerous, poisonous products and they're not responsible? I don't want to live in that world. I don't want, my children to live in a world where manufacturers can make the cheapest products. And it doesn't matter if the product is safe at all, who cares? And people can get hurt. I don't want to live in that world. So the first thing we need to know is if a person has a duty of care. Now, one question we ask is, was the person directly affected? There are other questions we're going to ask. And this is all in the video, and I really need you guys to start watching the videos because I don't have the time to go through everything. But there are 4 questions that we need to know. So number 1, proximity. Proximity means how close were the parties. Can someone tell me the difference between physical and legal relationship?
Yes. Hi. Hello.
Yep.
So the physical distance is like, okay, so there was that example where if I got hit by a car and like, what happens if there's a bystander? If there's a bystander, is that bystander really close to me? Would they have been hit by the car? That's the physical distance. And the legal relationship is that bystander my relative? Are they a friend? Are they an acquaintance? How,
Okay, so let me pause there. It's a little different. Physical distance is just how close are you to someone, physically. Are you in the same room? Are you in the same building? Are you on the same street? Where are you? You know, it is possible that I hurt you without being close to you. In the case where I was with Amar and I ordered a box of men's shirts and he sent me the wrong shirts, is he physically close to me? No, he's in China. I'm in America. We're not physically close at all. So that's one question. Are people physically close to each other? Another question is, what's our relationship? When we say relationship, usually what we mean is job. Doctor and patient have a relationship. Lawyer and customer have a relationship. In the case of Amar, we're talking about a buyer and a seller. That's a legal relationship. It has to be some sort of legal relationship. Friends is not a legal relationship. Neighbors, just because you live next to someone, is not a legal relationship. Boyfriend and girlfriend is not a legal relationship. It has nothing to do with money. Okay, the legal relationships usually are related to your job. So that's the first question, is were the parties close? Yes, Florian, question?
Husband and wife is a legal relationship.
No, not really.
Because it's signed by a contract.
It doesn't matter. It's a partnership, not a contract.
Oh, really? Okay.
Yes. Husband and wife is a partnership. So, and we'll look at it. We'll look at a court case in a little bit that has a husband and a wife. Okay, next is foreseeability. And this is a word that you absolutely have to understand. We're going to see it so many times this semester. Foreseeability is, can you see? But the question is, can you see that you have a duty of care? That's the question. Can you see that you have a duty of care? Not can you see the damages. Next is just and reasonable. Is it objectively reasonable to have a duty of care? So foreseeability is subjective and just and reasonable is objective. We need to know the difference here. First, let's reflect on how beautifully I drew an S and an O. Genius over here. That's beautiful. Harry, what's the difference between subjective and objective?
I think subjective is like based on personal feelings. Or like
sure, personal opinion. What's objective?
Objective is like an expression. It wouldn't be like an...
Objective is society's opinion. Not your opinion, everybody else's opinion.
Oh, yeah.
Let me take the example of a bus driver. You guys remember the case, maybe it was last year, where a bus in China drove off a bridge, killed a bunch of people? So let's say that I want to sue a bus driver. Now, the question, before I can sue the bus driver, so I'm riding a bus and the bus driver caused an accident and I got hurt, okay? Amar, I'm gonna ask you some questions about this bus driver, okay? Question number one, you're on the bus with me. The bus crashed and we both got hurt. We hurt our heads. We want to sue the bus driver. Number one, were we physically close to the bus driver?
Yes.
We're in the same bus. Number two, do we have a legal relationship?
Legal relationship, yes. Because
what is it?
His job is to be put us in a safe place.
Okay, driver, passenger.
Yeah.
That's our relationship, driver, passenger. Number three, foreseeability. Can, in your personal opinion, should a bus driver know that he needs to be careful when he's driving?
Yes, he should. That's his job. To drive us safely because I'm driving in a public transportation. So.
Okay, so he's being paid to drive safely.
Yes.
Number four, next, just and reasonable. In society, do we all want bus drivers to drive carefully and safely?
Yes.
Yes. And then next question, Lord Atkins neighbor test. Were you and I directly affected by this bus driver?
Yes.
Yes, because he crashed and was not careful, we hurt our heads. Now, because the answers to all of these questions are yes, the bus driver has a duty of care. Is the bus driver negligent? We don't know. Let's say, for example, Amar, why did the bus driver stop the bus suddenly? It's because there was a 5-year-old girl in the street. He stopped the bus suddenly. He saved her life, but you and I bumped our heads. We sue the bus driver. Does the bus driver have this duty of care to drive carefully? Yes. Are we going to win in our case against the bus driver? No. So what we're establishing with these 4 questions is not, are you going to win the court case? We're just establishing, does this person have a duty of care?
Yes, he
Is that
does.
clear?
Yeah.
Okay. Let's look at the next case, which I had asked you to look at for homework. This is CAPARO. So in CAPARO, the story is, let's say you have this electric equipment company, and it's not doing well. The share price is going down, so I start buying it. When I have 30% of the shares, then your annual account statement is released to shareholders, and I decide to buy your company. So Carlotta, let's say it's your company. Okay, unmute.
Yes.
Okay, so Carlotta, this is your company. Now, your company's not doing very well, and I'm an investor. And I think your company is actually a good company. I just think you've made some bad choices in the last few years. So I want to buy your company. Now, you have an accountant. Okay, Carlotta, your accountant is Nicola. Now, this quarter or whatever, you ask your accountant, hey, please prepare our financial statement. And when it's ready, you send it out to all the shareholders. And that includes me. I'm a shareholder. I get Nicola's, account, and I read it and I think, oh my God, this company is really good. This is really valuable. I got to buy this company. So the reason, Carlotta, that I'm buying your company is based on what Nicola wrote, his account summary. I'm like, oh my God, this is such a good company. It's so valuable. I think Carlotta just had a bad manager or something for a few years. I'm definitely buying it. So I buy this company. Once I bought it, I get my own accountant. Junpyo is my accountant. And I say, Junpyo, okay, this is my new company. Please look at all the numbers. He looks at the numbers and he finds out Nicola's report was totally wrong. This is a terrible company. So I want to sue Nicola. Now I say, Nicola had this duty of care. He had these responsibilities and he was careless and I got financially hurt. So Carlotta, I'd like to go through these 4 questions with you. Number 1, physical distance. Am I physically close to Nicola?
No, not at all.
I've never even met him, right? Number 2, legal relationship. Does Nicola work for me?
No.
No. Who does he work for?
Me.
Does he have a responsibility to you to be careful?
Yes, but I'm not
Yes.
suing.
Right, exactly. Does he have a responsibility to me?
No.
No. So we have a problem here, but okay, let's keep going. Subjective. So now we're talking about foreseeable. In your opinion, should an accountant see that he personally has a responsibility to be careful about these numbers?
Yes.
Sure, that's his job. People can get financially hurt. We agree subjectively, he should see he has a responsibility. Next is objective, just and reasonable. Do you think in society we want an accountant to be careful?
Yeah.
Sure. I mean, this is big business. And of course, in your essay, I'll ask you to really write down your reasoning. But for now, of course, we agree. And finally, was I, David, directly affected by Nicola's actions?
Yes.
Kind of. So I made a decision to buy your company based on Nicola's report. Was that a reasonable thing for me to do? Did he work for me?
No.
No. So this is a big problem. And the facts are pretty much the same. And what the court said is the defendant, who in this case is Nicola, the accountant, right? DICKMAN, in this case, DICKMAN was the accountant. And what the court said is DICKMAN had no duty of care because he didn't work for me. I had no relationship with him. Was I directly affected by him? Yes, but it was kind of like my choice to be. Carlotta, before I bought your company, could I have asked my own accountant, Jody, to look at the books?
Yeah.
Sure. Not Jody. My accountant is Junpyo. Should I have trusted your people before spending millions of dollars? Should I trust someone else's accountants?
You should have checked with your own people first.
And I didn't check with my own people, and therefore I can't sue you. I can't sue you, and I can't sue Nicola. Does that make sense, everybody? This idea of who has a responsibility is really important. Let's look at a couple of other examples of this.
Isn't it kind of fraud? Like,
no, he just made some mistakes. He was careless. Being careless isn't fraud. Fraud is when you lie to someone on purpose. He really did just make mistakes.
About these mistakes?
Well, sometimes mistakes are have very serious consequences, but they were still just mistakes. What about this mistake? A pregnant woman is getting off a train when she sees a man fall onto the tracks and die. She's so upset by this that she has a miscarriage and her baby dies. She sues the family of the man who fell onto the tracks for negligence. Is there a duty of care? Let's analyze this. Min, you with us?
Yes.
Okay. So Min, what's the first question for duty of care? You guys are killing me. Physical distance. This pregnant woman and this guy, are they physically close?
No.
Well, I mean, they're in the same place. They're not like in the same car, but they're in the same area. They're not like in different buildings. I mean, so I think maybe. What about legal relationship? Do they have any relationship with each other?
No.
No, they're total strangers. Subjective, so foreseeable. Should a man see that if he isn't careful at the train station and he falls onto the tracks, someone else could lose a baby? Should he see that? Min?
Yes, my internet was lagging.
Okay, you're frozen. Who's not frozen? Aruni, you're not frozen. Aruni, should a person see that they have a responsibility to be careful around the train tracks? Just that.
No.
Yes.
Just a responsibility to be careful.
They have a responsibility to be careful.
I think so. Trains are very dangerous. They're inherently dangerous objects. So he has a responsibility to be careful around the train. Objectively, in society, do we want people to be careful around trains?
Yes.
Yeah, sure. Was this pregnant woman directly affected by this guy?
Indirect.
Well, I mean, it was direct, right? She saw this and then she lost her baby. It's pretty direct. What's the problem in this case? This is Hay v. Young. Which of these four is the real problem here?
The real problem is he didn't take care, like duty care, like from himself. Like he didn't.
No, duty of care is all of these together. I want to know which is the problem. Is the problem that they weren't close? Is the problem that it wasn't foreseeable? Is the problem that it wasn't objectively reasonable? Or the problem is direct effect? That's what I'm asking you in your exam, to be able to understand these 4 questions. And I'll tell you, in this case, because we're just starting, the problem is foreseeability. Could this guy see that if he fell onto the tracks, a woman might lose her baby? No. He could never, ever see that that would happen. Now, in this case, the real case, it was a man who was driving a motorcycle, and he drove his motorcycle very badly, and he hit a truck and he died. And it was a very, very bad death. It was very upsetting. And a woman saw it, and then she lost her baby. And the court said, we're sorry, you can't sue him because the driver did not have a duty of care to people he could not foresee would be affected by him. Could you foresee that someone right around you, close to you, might be affected by you? Sure. But this was a woman who was pretty far away from him who just saw the accident. And there's no way, you know, could he see that other people on the road with him would be affected by his actions? Sure. If I hit a truck, I gotta know. If I'm driving carelessly, I gotta know that the people around me on the street driving are affected by me. But a woman who's, you know, across the street getting out of a bus, why would I think she would be affected by me?
Sir, sorry.
Yeah.
I would say like that's not on purpose accident, something like that.
Like premeditation.
But what does it matter if it's on purpose? Are you saying you can only sue people if it's on purpose?
No. Yeah. I mean like that. Because like, yeah, you're not on purpose, something like that. Like,
so
it's
if
an
I
accident
get drunk,
on the road.
if I drive a car and accidentally hit your daughter, you can't sue me because it's not on purpose?
No, you can.
And if I'm cooking for you in a restaurant and I accidentally put some rat poison in your food, you can't sue me because it's not on purpose?
Negligence.
You can sue people for being careless. You are not allowed in this world to be careless if you have a duty of care. Not everybody has a duty of care. You don't have a duty of care to Aruni, but if you work in a business, if you're a cook in a restaurant, you have a duty of care to your customers, and you have a legal responsibility to be careful. I don't care if you did it on purpose, you have a legal responsibility.
David?
Yeah.
In this case, the plaintiff won in the trial level, like the court's level?
Yes, and the court reversed.
And then there's the appeals, and then only the House of Lords.
Sure.
Okay.
The House of Lords reversed, yeah. Okay, let's look at another sad case. Actually, no, you can watch this on the video. I don't want to spend the time on it. Well, okay. Yeah, watch the video about it. The duty of rescue is an important idea. Do you have a duty to rescue someone? So in this case, let's say, for example, I'm riding in my friend's car and he's driving and using his cell phone at the same time. He hits a tree and I'm seriously injured. Instead of helping me, my friend runs away. And so I sue my ex-friend in court and I argue that because he ran away and left me, my duties became worse. I say he had a duty of care. And he says he had no duty to rescue even if he had a duty of care. Did he have a duty to rescue me? Yes. What do you think, Harry? Harry?
Yes, sorry, I'm just reading it again. Yeah, I guess so. I think yes.
Why? I mean, I'm not asking you for your opinion. I'm asking you for the legal rule.
I think the rule would be
Can I answer that?
Sorry?
Can I answer?
For the 4 reasons.
Sure.
Direct.
Because he was a passenger with his friend, and he was the driver. So it
direct
was his responsibility.
That's not the legal rule, though. You're telling me like common sense logic. This isn't common sense class. This is law class. If you didn't do the work, then you don't know the answer. I'm not asking anybody to guess. If you didn't watch the videos and you didn't look at the PPT, please don't take a wild guess. That doesn't help anybody. Then you're just going to give everybody the wrong information. Okay, there is a duty to rescue. There are rules. Okay, this is law class. So we have actual rules. We're not just guessing here. So the old rule about law is that you can't leave someone worse off than you found them. You can try to rescue someone, but you can't leave them worse. Now, what that meant in the old rule is that if I tried to rescue you, let's say that Harry, you got hit by a car and you're in the road. And I'm like, oh my God, Harry, you're in the road. Let me help you. In the old way, let's say that, Harry, I try to help you. So you got hit by a car and your leg is broken. Now, I'm not a doctor. I don't know anything about how to really help people. But Harry, I grab your arms and I put my arms under your shoulders and I pull you out of the street. Now, because I did that, let's say your leg is hurt worse. In the past, Harry could sue me because I left him worse. Of course, I didn't do that on purpose. Now we have a new rule, which is the idea that if I want to rescue someone, I just have to be reasonable. Is it reasonable for me to try to get Harry out of the busy street? Sure, it's reasonable, and therefore he can't sue me. In most places in developed countries, there are Good Samaritan laws. And a Good Samaritan law means if you try to rescue someone, you cannot be sued. China does not have Good Samaritan laws. So I'm sure a lot of you guys might have heard stories of like, if someone falls on the ground, especially like an old woman in China, do not help her. I don't know, have any of you guys heard that?
Yeah, it's so many here. It's happening, but nobody.
And people have said to you, don't, if somebody falls on the ground, don't help them. Why is that?
It's
because they. Oh, okay.
What do you think? Why is that?
You can be sued because you caused her more trouble once you touched her to help her stand up.
Well, I mean, she's going to argue or yell or scream to the police that you pushed her. And there's no evidence that you didn't. And right now in China, there's no law that says if you try to help someone, they can't sue you. So this is important. It's changing, but it hasn't changed yet. So it began to change in China. Let's see, the first time recently was in 2006. This was the first big case. And it was a 65-year-old woman who sued this boy, and he was forced to pay 45,000 RMB to the woman, even though he was just trying to help her. And then a lot of people started talking about this on the internet. The next really big case was in 2013, where there were these 2 kids in Sichuan, and there were 4 kids, 2 boys, 2 girls, and they went to this lake, and the girls fell into the lake, and the boys jumped in to try to save them, but they couldn't save them, and the girls drowned. And the boys were forced to pay 50,000 each, even though they tried to save the girls. So now this has become really big news, and after that, in 2013, SHENZHEN passed the first Good Samaritan law in China. That was the first time in China that they had passed that. It's still not in most cities in China. So if you do help someone, you can still be sued, but it is developing in China. There are a few times where you really can be sued, even in America, if you help someone. So for example, in a case where you've created a dangerous situation, if I create a dangerous situation and you get hurt, then that's my fault. Of course, I have to rescue you, if I'm the one who created it. Or if my instrumentality created the harm. For example, if I have an instrument like a gun, I have a gun in my house and you're playing with it and you hurt yourself, I caused you the harm by having the gun. I need to rescue you. Or, and this last one is what I really want to talk about. Defendant creates in plaintiff a belief that plaintiff can rely. We're going to see this word in law a lot, this word rely. So what does it mean to say you can rely? So for example, if I say to you, hey, Caitlin, you know, I'm a very professional mountain climber. And this weekend, let's go mountain climbing. And Caitlin says, I don't know, I feel uncomfortable doing that. I don't really, you know, I've never done it before. I'm a beginner. And I say, Caitlin, you can trust me. You can rely on me. If anything goes wrong, I'll get you to a hospital. Now, do I have to get you to a hospital if anything goes wrong? Yes, because I said something. I created a belief and that she could rely on me. And we're going to see this again and again in the law, that if you create a belief that someone can rely on you, then they can. And so in this case where I was riding in my friend's car and my friend crashed into a tree, my friend did have to help me. Why? Because he was the one driving the car, right? He created the peril. He created a dangerous situation by driving a car and hitting a tree. Now he needs to rescue me. Min, if you see someone get hit by a car, do you need to save them?
Yes.
According to who? Why? Are any of these situations true? Did you create the situation where they got hurt? No.
No.
Was it your car? No. Do you have a special relationship like a doctor and a patient or a lawyer and a customer? No, it's just a stranger. Did you make a contract that you would save them? No. Did you tell this person that you would save them? No, you don't know them. So do you need to save them?
If based on the
yes.
law, I don't need to.
I'm not asking if it's ethically right to save them. It probably is ethically right. But in the law, do you have to save a stranger or can you watch them die?
You cannot.
Now, some countries say that you have a duty. For example, in Canada. In Canada, if you see someone get hurt and you can help them, you have a positive duty to help them, an affirmative duty. Most countries don't have that. As I said at the beginning, if you undertake a rescue, if you try to rescue someone, then you need to be careful. So if I see that Harry got hit by a car and I want to get him out of the street, can I grab him by the hair and pull him out of the street? No, that's clearly not a good way to save him. But do I have to save him at all? No. Why? Why don't we make a law everywhere that everyone needs to save everyone? Jody, what do you think? Why don't we have a law that everybody needs to save everyone?
For me, like it's probably the same, like what like China says.
Sorry?
Maybe someone can sue you because maybe the one who got the accident will be will feel like he had the damage by the people who wants to rescue.
Sure, and maybe he will sue them. Sure.
Yeah.
The other reason, so I agree with you, and I think there's another reason, and the reason is in the law, we have to be very careful about legally forcing people to be good. We get into a very strange world when people have to be good, not because they should be good, but because the law makes you be good. It gets into very uncomfortable philosophical world where we don't know why people are being good, but they have to be good. So philosophically in America, we don't like that idea that you have to be good. So really, you don't have to save people. Now, what about this? So I got in this accident with my friend in the car. Let's say, Junpyo, you were the one driving, okay? And now, Junpyo, after this is all over, you come over to my house and you say you want to talk, but you want to use the bathroom first. And I know that the bathroom door is broken and the edge of the knob is very sharp, but I don't tell you. And of course, you cut your hand. Can you sue me?
Yes, I think so, because it's like similar to the one that you made an example about Tikan, maybe.
About what?
Tikan. Like if I'm playing with your gun and if I hurt myself, like I can still use. I mean, you have to rescue me.
Tell me about the 4 tests for duty of care, because that's what I want to know. I don't want to know common sense and I don't want to know opinions. Proximity, are we physically close?
Yes, we're in the same house.
Do we have a legal relationship?
We don't.
No, we're just friends or ex-friends or whatever. Foreseeability. Should I see that I have a responsibility to tell people if my apartment is dangerous?
Yes.
Yes. In society, do we want people to tell someone if their apartment is dangerous?
True.
And were you directly affected by me?
I think so.
Yeah, because if I told you, you'd be careful. So therefore, I have a duty of care to you. But that's just a duty of care. The next question is, did I break my duty of care? So the first thing we need to know, does someone have a responsibility to someone else? After that, then we want to know, did you break your responsibility? So we say duty of care is a matter of law and breach is a matter of fact. So what does that mean? So duty of care is a matter of law, which means we're just talking about relationships, not details. Let me stop sharing for a minute so I can see you. Duty of care is a matter of law. When we talk about duty of care, Jordan, can you tell me the 4 questions in duty of care?
Just dealing, right?
Jordan, you're muted.
Physically close, foresee.
No, the first one is called proximity.
Proximity close, yeah. And
proximity, just a minute, proximity has 2 parts.
Mm-hmm.
What are the 2 parts of proximity?
Physically close and legal relationship.
Okay, that's the first test.
Yeah.
What's the second test?
The second, foreseeable.
And is that subjective or objective?
Subjective and objective. Yeah.
No, it's only, wait. The foreseeable test is subjective.
Subjective. Yeah. But in my opinion here right now is objective.
No. The foreseeable test is a subjective test.
A subjective test, okay.
Yes. It's always a subjective test. Crystal, what does that mean?
Subject to individuals, like in personal.
No, with that sentence, the foreseeable test is a subjective test.
You mean explain the sentence?
Yes.
It's like whether you can foresee yourself or an individual have a legal responsibility to. Good.
Okay, can you see yourself having a responsibility? Sometimes you can't. Sometimes I might ask a doctor, hey, do you think you're responsible? And the doctor would say, no, I don't. That's why we also need to ask, what would society say? Sometimes I might ask a bus driver, I might ask someone who makes ginger beer, hey, do you think you're responsible to everybody in the world who drinks your beer? And they may say, no, I don't think I'm responsible. So it's possible that someone does not think they're responsible. Now, Jordan, what's the third test?
The third test is just
and reasonable.
Just and reasonable, yeah. Just and reasonable.
And is that subjective or objective?
Could be subjective.
No, could be. No, could be.
Okay, objective.
Yes, it is objective. It's an objective test. And that test says, in society, do we think this kind of job has a duty of care? Do we think in society a teacher has a duty of care? Maybe I don't think I have a duty of care, but that's just me. That's just my opinion. So we also want to look at what does society think, objectively. Now, this is a matter of law. So when I say a teacher has a duty of care, does it matter if it's a male teacher or a female teacher? No. Does it matter if it's a 60-year-old teacher or a 20-year-old teacher, a university teacher, a primary school teacher, a fat teacher, a thin teacher? Doesn't matter at all. Those are facts. And when we talk about duty of care, facts don't matter. It doesn't matter if you're tall or short or old or young or thin or Mexican or American or, you know, black or white or whatever. None of it matters. Teacher, student, bus driver, passenger, doctor, patient, seller, buyer. That's it. That's the only thing that matters for duty of care, is these legal relationships. However, when we talk about breach, did you break your duty of care? Now we have to talk about the facts. Now it matters what situation this person was in. So when I say, for example, can a teacher grab a student? Or can a teacher, like, you know, hug a student or something? Now the answer probably would be no. But let's say now we're talking about a 21-year-old female teacher who teaches kindergarten. The kids are 3 years old. And one of the boys is trying to bite one of the girls. And the teacher held the boy. Compared to a teacher who's 65 years old who teaches university and grabbed a girl. Now we have to look at the facts, because those two situations really are different. Just like we said, can a bus driver hit the brakes really fast? No, they can't. But what if there's a child in the road? Well, then yes, maybe they can. Does a bus driver have a duty of care? Yes. Did the bus driver break their duty of care when the child was in the road? No, they didn't. So if you sue them, you're going to lose. So now let's get into this idea of what it means to break a duty of care. Because now the first question is answered. Do you have a responsibility as a bus driver? Do you have a responsibility? Duty of care means responsibility. Do you have a responsibility as a bus driver to be careful, as a teacher to be careful, as an accountant to be careful, as a doctor to be careful? Sure, you do. And how do we know? 4 questions. Proximity, foreseeability, just and reasonable, and Lord Atkins' neighbor test, direct effect. Now we need to know if you actually broke your duty of care. And we have 4 other questions. Question 1, risk of harm. Let's say that let's say I'm teaching you guys face to face, and I bring a gun to class. And I put the gun on my teacher's podium, my little desk. Now, when we talk about risk of harm, there are 2 sides here. One is called likelihood, and one is called seriousness. If I put a gun on the counter, on the desk in class, how likely is it that someone will get shot accidentally? Is it very, very likely it will definitely happen, or is it not very likely? What do you think?
If it's loaded, it's definitely gonna happen. But if not
You
loaded,
think, wait, you think a loaded gun definitely is going to fire? Why?
accidentally, if you touch it, maybe you can
What?
fire.
I'm not going to touch it. I just put it there for all of you to see. Hey guys, I bought a new gun. Look how shiny it is. And then I put it there. That's it. I'm not even going to touch it. Is there a high chance that someone will get hurt?
Yes.
No, there is no, it's not going to get hurt. Okay, let me change the example. I bring a bow and an arrow to class. They're separate. Here's the arrow, here's the bow. And I put them both on my desk. Is there a high likelihood someone will get shot with this arrow?
No.
No. However, so the likelihood of harm is low. What about the seriousness? If someone did get shot with an arrow, would the possible seriousness of that harm be high or low? High, right? If you get shot with an arrow, you could die.
Yes.
So the likelihood is low and the seriousness is high. And these are the two things we need to balance in this first test called risk of harm. There's some times where the likelihood of getting hurt is very high, but you're not going to get very hurt. The seriousness is low. And sometimes where the chance of getting hurt is low, but the possible seriousness is very high. Next question is the reasonable person standard. Now, in the law, we talk a lot about this imaginary reasonable person. Would a reasonable person do this? Would they act this way? Then the third question is social benefit. Is there any benefit, like in my example with a bus driver? The bus driver stops the bus very quickly, and Amar and I both hit our heads. Is there, Amar, what's the social benefit of the bus driver stopping very quickly?
Like you can bump your head like in anywhere.
But why did he stop the bus so quickly?
Because of the girl.
And what's the social benefit of him stopping the bus?
Carry duty, like he
like saves this girl's life. Yeah, he saves a life. So we could sue him, we're gonna lose because the social benefit is so high. What about the cost of minimizing the risk? What would it cost us to be more careful? Sometimes actually the cost is very, very high. Sometimes it's almost impossibly high. Let's say, for example, that outside your house right now, wherever you are, there's probably electrical wires. We all have electricity wires outside. Are those electricity wires dangerous, Crystal?
Of course.
Yes, right? They're dangerous. And that, if, you know, that's a really dangerous thing to have right outside our house or our apartment, is something that could kill us if we touch it. So why don't we make the companies make every wire in the entire country safe? Why don't we make the electric company make every wire in China safe, every wire in America safe, every wire everywhere?
Cut down the electricity.
How much would it cost the electric company to go and make sure every wire in the entire country is totally safe if you touch it? It's not even a possible amount of money. It's just an impossible amount of money. Could they do it? I guess. I mean, maybe they would shut down the electricity in a whole city and get thousands of people and wrap them with tape. And I mean, I guess maybe. But the cost of doing it is just insane. It's just impossible. So if you climb up, because you're an idiot, and you climb up one of these poles and touch a wire, can you sue the company? No. Even though the risk of harm is high, because the cost of them fixing it is impossible. So we need to understand these four. So as I said, the first test is a balance. The risk of harm test is a balance between how likely is it that you will experience harm and how serious is the harm.
Sir, Sir David, may I ask something?
Yes, but you don't have to call me Sir David because I'm not a knight.
Sorry. For the before like the case of the bus driver.
Yes.
So if like the girl passed the road without the the zebra cross, like just on the road, and then like the girl passed the road without a zebra cross, zebra cross in on the lights, and then can the bus driver sue the girl who is passing the road because the girl made a bridge?
The girl, so let's say the light is red, the girl should not cross the street. So she's crossing the street illegally.
Okay, something like that.
And the bus driver gets hurt. Could he sue the girl? So yes, she broke the law.
Yes.
He could sue her. Now, if she's under 18, then he's going to have to sue her parents. And you can do that, and we're going to learn about that in your midterm exam. And that's called vicarious liability. That's where you sue a third person. We usually do that in the case of suing a boss. So let's say that I do a bad job teaching you, and I teach you the wrong things and you fail the test. You could sue me because I'm a teacher, you're students, I have a responsibility to you. Could you sue my boss? Yeah. And that doesn't seem fair. Elaine didn't do anything to hurt you, but you could sue her because she hired me. And whenever you sue a third person, that's called vicarious liability. And that's also to sue the parents. The most famous case of that is there was a kid who was 8 years old. I think he was 8, maybe he was 6, but I think he was 8. And there was this birthday party. And it was the kid's birthday party, and his aunt was there, and his aunt was very fat. And she went to get some birthday cake, and she went to sit down on this little like children's chair. And the 8-year-old pulled out the chair. So she fell down and she hurt her hip. She broke her hip. And she sued this 8-year-old child. And of course, you can't sue an 8-year-old child because it's void. You can't sue a child. So she sued their parents because she had to. She needed the money for the operation. She didn't have the money. And the question was, should an 8-year-old child know? Is it foreseeable? Caitlin, what do you think? Could an 8-year-old child foresee that if they pull out a chair, someone could fall?
I think yes, but then I don't think an 8-year-old child would care.
Absolutely, but that doesn't matter.
Then yeah, they would
just
foresee
matters.
that.
Remember, we talked about the know or should have known. He didn't know. Look, if you told him, if you pull out this chair, your aunt is going to cry and she'll be in the hospital for weeks. And I mean, maybe he would care. He just didn't understand the extent of the damage. He didn't understand how serious. But he understood, if I pull the chair, she will fall. Now, of course, he just thought that was funny because he didn't understand why that's not funny. And to be quite honest, it is pretty funny. But she hurt herself very badly, and therefore, yes, you could sue. So Jody, to answer your question, yes, you could sue this girl for having caused this accident. Okay, back to risk of harm.
Also, the passengers can sue the girl.
Sorry?
And also the passengers can sue the girl?
Yes. Yes, they can. Yeah, if you do something that's dangerous and you cause harm, you can be sued for it. Okay, let's look at an example. Again, just stuff that was on the video. So in the future, I won't go through stuff quite as delicately as this. So I have a house near a small baseball field, and I watch the children play ball. The field is almost 100 years old. It has a high fence around it. I've lived here for 20 years, and no one has ever hit a ball over the fence. One day I'm outside and a ball flies over the fence and it hits me in the head, and I sue for negligence, saying they knew of the danger. What do you think? Harry? Harry, do they have a duty of care? Proximity. Are we in close proximity?
Yeah, it's fairly close.
Okay. Is there a legal relationship?
No.
Okay. Subjective. So foreseeable. Should this baseball club know that it's dangerous to hit baseballs near people's homes?
Yeah, I think so, yeah.
In society, objectively, do we want something like a sports club to be careful of the homes around near where they play?
I guess so, yeah.
I don't think I don't think we want balls flying around outside sports clubs, so I think that's fine. Was this woman directly affected by the club?
Yes.
Yeah, absolutely. So they have a duty of care. Now, let's talk about breach. Did they break their duty of care? Question 1, risk of harm. How likely is it? Is the likelihood high or low that she would get hit?
Very, very low.
Incredibly low.
Yeah.
Is the seriousness high or low?
It's to a certain degree. I wouldn't say it's completely high, but yeah.
Yeah, I mean, it's not like a gun. It's not like you're definitely going to die. But I mean, if you get hit with a baseball, you could get very hurt. It's possible. You know, and this was the case. Now, in fact, this woman in 1951, she lived in this place where there was a cricket club since 1864. It had been there, you know, almost 100 years. And only 6 times in the last 30 years had a ball been hit that far. And she knew this. So with the trial court dismissed. They say, look, there's no accident for 30 years. You moved into this house. You knew the danger. But the Court of Appeals reversed. They said, no. The defendants, which is Stone, it represents the baseball club. They said the defendants, the baseball club, they knew there was a risk. And they did not protect against this risk. So the court had to balance this. Okay, they said the risk of harm may have been foreseeable, but the likelihood was so low. A and B, so we have 4 things, A, B, C, D. A and B are the likelihood of harm and the seriousness. If we put those onto a scale, how likely is it that she'd get hit? Very low. If she gets hit, how serious is it? You know, maybe in the middle. So take those 2 things and put them on a scale. Along with C or D, what's the cost of preventing this accident? How do you make sure? How do you make 100,000% sure that no one ever gets hit by a ball near a ball field? Can you?
Indoor stadium.
So, okay, either it's 100% indoors, and the cost to do that was impossible. It would cost millions of dollars. They don't have the money. Or you don't play. That's it. Those are the only options. If you want to be 100% sure that she never gets hurt. And then D, what's the social benefit of cricket or sports? I mean, it's pretty high. The usefulness of playing cricket. So they said if you put all of these things on a scale, the likelihood and the seriousness versus the social benefit and the cost, the likelihood and seriousness are a little bit lighter, and therefore she loses the case. And let's look at another example. I'm a car mechanic, and one day my boss tells me to do some work on the underside of a car. There are no goggles, so I did the work without the safety equipment. A piece of metal flies off and hits me in the eye, and now I'm blind. So I sue my boss for negligence in not providing safety equipment. Now, we can go through the tests, right? Proximity, foreseeability, just and reasonable, Lord Atkins neighbor test. But let me just say, of course, the boss has a duty of care. The question is, did they break the duty of care? If I'm working on a car without any safety equipment at all, Nicola, if I'm working on a car without any safety equipment, is the likelihood that I'll get injured in some way high or low?
I I would say in the middle, more
Maybe
high
the
than
middle.
low. So,
I mean, cars have a lot of parts. They can be very hot. Some of the parts move very fast. There's oil. It's slippery. I have to use tools. I'm not going to definitely get hurt, but there's a real chance that I might if I don't have any gloves or any goggles or anything. If I get hurt by a car, is the potential seriousness high or low?
also in the middle. I think.
Also
I mean,
in the middle.
depends of the damage.
Okay, so that's our A and our B. Is like likelihood is in the middle and seriousness is in the middle. We put those on the scale. On the other side of the scale, what would it cost my boss to get the right safety equipment? Millions and millions of dollars?
No, not that much. It would be
It would cost
affordable
him,
price.
absolutely. It would
Very
cost him
affordable.
almost nothing. Is there any social benefit, a benefit to the whole world that he didn't buy safety equipment?
I would say it.
How does that
Yes, I
benefit the
mean,
world?
not the world.
Does it
But
benefit
like,
anybody?
I think yes. Like if he gets hurt, he have to go to the hospital, and
No, I'm saying the fact that he did not have safety equipment.
No, not at all.
Right, there's no benefit. So C and D are almost nothing. It costs him nothing to fix it, and there's no benefit to him breaking this. And A and B are both in the middle. So A and B are obviously heavier, and therefore A and B, the likelihood of harm and the seriousness of the injury are much greater than C and D. Therefore, he broke his duty of care, and I win.
I see.
Carlotta,
Although
he
that's
looks
also
so
like
tired.
a personal duty of care of the people. I mean, the guy, the mechanic, he also have this own duty of care, right?
Yeah, but he didn't harm anybody.
Yeah, I mean, but
he got hurt.
He would wear the protection.
You don't have a duty of care to yourself.
Of yourself, okay.
I mean, of course he would have worn this if he had it. Okay, Carlotta.
Okay.
Carlotta, next one's for you. You needed some coffee before the next class. Is it like 6 o'clock in the morning where you are or something? What time is it?
No. It's just 1 hour less.
Oh, okay. 1 hour less. So it's 9 at night?
No, in China time, I mean.
Oh, okay.
1 hour less.
All right. So Carlotta, I'm a fire department chief, and I receive a call that this woman is trapped under a car. Okay? So at the fire station, we have this special equipment that we can use to lift a car. But this is very heavy. It's like a crane. It's very heavy. And we have this special truck for it. But right now, that truck is not available. But this woman's going to die. So I'm like, you know what, guys? Let's just get this thing and put it on one of the regular fire trucks. And I know that's not the right truck, but whatever. We have to save her life. So we put it on the regular truck. And as we're driving there, it falls off and it injures one of the firemen. So he gets injured. Now, we did get to the woman and we did save her life. But this fireman now, his leg is broken. And so he sues me. And the question is, let's go through duty of care first. Did I have a duty of care to him? So are me and this fireman pretty close physically?
Yeah, there's a close proximity. There's a relationship because you're colleagues.
Wait, we're not colleagues. I'm the chief. He's below me. We have a boss, a master-servant relationship.
Yeah, there's foreseeable. The boss could have seen that it could have been a problem. I mean,
that's not exactly the question. Should the boss see he has a responsibility? That's the key word. It's not seeing a problem. It's not seeing a danger. It's seeing a responsibility. Should the boss, the fire department chief, see he has a responsibility to be careful with this heavy equipment?
Yes.
Yeah, sure.
Um,
Next, just and reasonable.
Oh, It was like it is reasonable that reasonable that he used the
Just and
machine.
reasonable is the objective test. So in society.
Oh, in society. I would say that most people would not think that the boss is guilty.
Okay, but wait, that's not the question. You're jumping away from the law. I never said anything about guilty or innocent. That's not at all what we're talking about. We're talking about duty of care. What's another word for duty of care? Anybody, what's another word for duty of care?
Responsibility?
Yes.
Responsible, accountable.
Responsibility.
Yeah.
So the only thing, Carlotta, that we're talking about is the fire chief responsible?
Yes, it is.
Because if he's not, you can't sue him. That's it. I mean, that's the first question. Like, let's say you and Tiffany are walking on the street. You have no responsibility to her. She has no responsibility to you. You're just two people. So like, if you don't have responsibility to someone, there's no way they can sue you. So that's always our first question. It's not about guilty or innocent. It's just about, does this person have responsibility? So the first question, are they close physically? Yes. Do they have a legal relationship? Yes, boss and employee. Next, subjectively, should a fire chief see that he's responsible for all this heavy, dangerous equipment? Sure. In society, do we want fire chiefs to be responsible for all this equipment?
Yes.
Yeah, absolutely. They have all this equipment. It's dangerous, these big trucks. We want them to be responsible. And finally, was this fireman who broke his leg, was he directly affected by the fire chief's decision to put it on the wrong truck?
Yes.
Yeah, absolutely. So what do we get by answering those four questions? We get the answer, the fire chief had responsibility. That's all we get from the first four questions. What do we get from the second four questions? Anybody, what do we get from the second four? The first four tell us this person had responsibility. What do the second four questions tell us?
It's about the facts.
Yes, that's true. But what do we get from these four questions?
The risk of harm?
The risk of harm is just the first of four questions. So what we get from the questions is, did this person break their responsibility? Sometimes you have a responsibility, but that doesn't mean you broke it. Let's say that I teach you guys law, okay? This is really, really important stuff. So let me stop sharing for a minute, because this is the key really to understanding negligence. And after we take our break, we're going to come back and I'll talk to you about your midterm, and you'll see almost all of the midterm is about understanding duty of care, breach, damages. So duty of care, again, what's another word for duty of care?
Responsibility.
Okay, responsibility. And we have four questions. Caitlin, what do these four questions for duty of care tell us?
They tell us the proximity and...
No. What it, as a whole, what do these four questions tell us?
The level of responsibility the plaintiff has over the harm the defendant fell under?
Okay, I think that's fine. The level of responsibility. I would just say, is this person responsible? That's what they tell us. That's what the four questions tell us. Sure, if you want to say it that way, that's great. Is the plaintiff responsible for this harm? Sure. But, you know, you have a person. Are they responsible? Now, we have four questions for breach. What do those four questions tell us? Did this person break their responsibility? Because sometimes, so my example, I'm a teacher, and I'm going to teach you guys law. So let's say I teach you law and I give you these videos, and sometimes I get angry and I say, come on, you got to learn this. And I teach you all this stuff. And then let's say that one of my students, Min, who has disappeared again, back and forth. So let's say that Min didn't come to class, and then she fails the class. We can go through the 4 questions for me and you guys, but do I have a responsibility to teach you law?
Yes.
Yes. Now, if you don't come to my class, you don't do the work, you don't watch the videos, did I break my responsibility?
No.
No. So the first thing we need to know is, did I have a responsibility? The second thing we need to know is, did I break my responsibility? Then there's a third thing we need to know. Did you get hurt? Sometimes I have a responsibility and I broke my responsibility, but you didn't really get hurt. We need these 3 things. So we've already done the first big thing. Does someone have a responsibility? And that's 4 questions. Now let's go back and continue with, does someone break their responsibility? I just want to do 2 more cases and then we'll take a break. Okay, so we just did this case, and this was, I think, Watson v. Hertfordshire, right? And the fire authority was not negligent. So in this case, you had this fire chief. Who was I just talking to about this? Is that Caitlin? Caitlin or Carlotta? Who was I just talking to?
Both, but me first and then Caitlin.
Oh, okay, Carlotta, let's stick with you. Okay, so Carlotta, there's this fire chief, and he has a responsibility to his employees. And now we're asking these 4 questions to find out if he broke his responsibility, okay? Question number 1, what's that called? What's the first question for breach? Yeah, Florian?
It's like seriousness and
and likelihood. But what's the name of the question?
The name of the question.
A reasonable risk of harm.
Risk of harm. Okay?
Yeah.
Risk of harm, right? I said there are 4 questions for breach. To see, did someone break their responsibility? We have 4 questions. Now, let's talk about this fire chief, Carlotta. Number 1, risk of harm. And I said risk of harm is balancing these 2 things, likelihood and seriousness, okay? Now, how likely is it that this big, heavy thing is going to fall off the truck? Is that definitely going to happen?
No.
No, but it's very likely.
Well, who knows? But I mean, I'd say I don't think it's that likely to fall off. It might happen, but I mean, it's not a definite, you know? However, if it falls off, it's very heavy. How serious could the harm be?
Serious?
Could be serious. So we're talking about a pretty big A and B on this side of the scale. Now, what about the C and D? What is the social benefit of me, the fire chief, putting this on the truck?
It's high. Saves a life.
To save a life. And if I don't put this on the truck, how much? What's that going to cost? A life. Yeah. And that life that we saved is way heavier than a person's broken leg. And therefore, what this court said is the fire authority is not negligent. Did he have a risk of harm? Yes. You know, but the risk to the fireman had to be balanced against the purpose to be achieved. So you had this likelihood, right? The likelihood of someone being hurt is A, the seriousness of someone being hurt is B, and then you balance those 2 against the cost of minimizing the risk and the benefit of saving someone's life, which is much heavier. And so therefore, there's no negligence. Reasonable man standard, what does that mean? Reasonable person now, we say. So 25 years ago, let's go back to Caitlin for this. Okay, Caitlin, 25 years ago, The local government installed pipes and fire hydrants in the area near where I live, and there have never been any serious problems for 25 years. But this winter was the coldest winter ever. And on one of the coldest days, a water pipe broke near my house, and water rushed in and caused a lot of financial damage to the things in my house. So I sue the water company. Okay? Let's go through duty of care first. So we have 4 questions to see, is the water company responsible? Question 1, proximity. Is the water company physically close to me? That includes their pipes.
Oh, yeah. If
You're
the pipes in your
very
house, then
close.
yes.
You are very close at all times to every utility. You're close to water, electricity, and gas at all times, pretty much. So they're close to me. Do I have a legal relationship with the water company?
Yes.
Yeah, I'm their customer. Okay, so proximity is a yes. Foreseeability. Should a water company see that they have a responsibility to have good quality pipes?
Yes.
Yeah. In society, do we want water companies to be careful?
Yes.
Sure. And was I directly affected by them having a bad pipe?
Yeah.
Absolutely. So they have a responsibility to me. Done. Now, did they break their responsibility? 4 questions. Number 1 is risk of harm. Okay, we're now at our balance. How likely is it that if their pipes break, you could get damage from flooding?
Oh, hi.
Yeah, very high. What about the seriousness? Is anybody going to die from the flooding?
No, maybe, probably low, medium maybe.
Yeah, I mean, it's maybe low middle because it's financially pretty
Yeah.
serious, but it's not physically serious. But I mean, it's very likely kind of serious. So that's on one side of the scale. Now, on the other side of the scale, is there a social benefit to having like water pipes that break in the winter?
A benefit? No.
Yeah, is there anything good about having water pipes break in the winter?
No.
No. What would it cost them to fix these water pipes?
Oh, millions of
Maybe.
dollars.
Okay, so that might be a problem. That question might be a problem for us. But we have another question. We had risk of harm, reasonable person test, and then social benefit and cost of minimizing the risk, right? Those were our 4 tests.
Mm-hmm.
And when we did the balance, we talked about risk of harm, likelihood and seriousness versus social benefit and cost. But we haven't yet talked about this question, right? If there are 4 tests, when we talk about this balance, we put likelihood and seriousness, that's question 1, on one side of the scale, and we put these 2 on the other side of the scale, and then we balance between these, right?
Mm-hmm.
But we never talked about this question. So what about a reasonable water company? Would a reasonable water company think that those pipes are going to be okay? What happened for the last 25 years?
Nothing.
So why would a reasonable water company think this year is going to be different?
No, they couldn't predict that it would be this.
They could never predict that, right? Was this water company reasonable in thinking it'd be okay?
Yeah.
Yeah, they were, and therefore they're not responsible. Okay, so the reasonable person test is still this idea of foreseeing, foreseeability. This is an old case from 1856, but it's still a very important case because for a reasonable person, we need to know, could you foresee that this situation would happen? If you could never foresee it, then it's really not your fault. One last case before we take a break. Okay, New York power lines. New York Power Company has electrical power lines behind my apartment building. I touch one with a ladder, I die. Do they have a duty of care? We could go through the tests, but we know the answer is yes, they have a duty of care. Jordan, did they break that duty? Let's go through the 4 tests. Number 1, risk of harm. How likely is it that someone will touch a power line?
It's high. It's really high.
Really, Jordan, have you ever touched a power line?
No, I never touched it.
Have you ever met anybody in your whole life who touched a power line?
I saw some videos, but I never met some.
Yeah, that doesn't count. I've seen videos of amazing things
Yeah.
that are not very likely. I've seen videos of UFOs. That doesn't mean they're likely. So how likely is it, high or low, that someone would actually climb a ladder and grab a power line? Low. It's
Low,
very low. However, if you do it, is the seriousness of the harm high or low?
I think low.
You're killing me here. If you grab a power line, you will die.
Oh, yeah.
You will die if you grab one.
Yeah, that's high.
Yeah, it's high. The likelihood is low. The seriousness is extremely high. What about the social benefit? Is there any benefit to having such dangerous wires outside our homes?
No.
There's no benefit to them being dangerous. Of course, there's a big benefit to having electricity, but we're asking, is there a benefit to them being dangerous? And no. But what about the cost? How much would it cost, high or low, to make all the power lines in the country safe?
I think
millions.
I think it's a number we can't even count.
Yeah.
Right? The cost of fixing these power lines is so impossibly high that the court said, listen, now in this case, actually, you can read it, but in Washington versus Louisiana, a guy did not climb a ladder. He was using a remote control that had a very long wire, and he touched a power line, and this was the third time he'd done it. And the first two times, the power company said, stop using that remote control. You're going to touch a power line, and you're going to die. And he said, no, I won't stop playing with my car. And then he touched the power line, and then he died. So the court said, look, this guy knew. You know, there was a big possible injury, but a very small possibility of this happening. And the cost of minimizing the risk was much too small. Okay. So it's now almost 10. The next thing we're going to get to is talking about damages, which is the third part of torts. What I'd like to finish today is I'd like to get through most of the damages part, because then you can begin to write your essay. So what I'm going to do is when we come back, let's take 10 minutes, and we'll come back at 10:03, and then, or in 10 minutes for you, and then we'll talk about your midterm. I'll go through the whole midterm with you. I'll show you step by step what it is. I'll read it. We'll read it together. We'll talk about it. You'll see what I want you to do. And it's big. I mean, this takes weeks to do, but I'll tell you what I want you to do for homework this week on the quiz, okay? So let's take a 10-minute break. We're recording again. Any questions on what we've talked about so far? The 4 tests for, well, first of all, what is negligence? It is a tort. It is a civil wrong. And that negligence has 3 parts: duty of care, which means responsibility; breach, which means to break a responsibility; and damages. And there are 3 kinds of damages: emotional, physical, and financial. And then we learned for negligence, the first part, do you have a responsibility, has 4 tests. And the second part, did you break your responsibility, also has 4 tests. That's what we've learned so far today, and that's a lot. So are there any questions?
So in the case,
Jody?
go ahead.
For the duty of rescue, do we have any duty of rescue ourselves?
What do you mean? Do you mean to rescue?
What I mean, like, I had I have a case like in my country. I would say, like, if a robber came to our house, and then we maybe have a gun or maybe something that, and then we kill the robber, and then the country will say that I'm wrong because I killed someone.
Okay, so there are a bunch of cases like that in America too, which sound crazy if you don't know the context. You know, there are cases, for example, there's a case where there was a guy trying to rob a house and he was climbing on the roof and he fell in through a window on the roof. He fell in and he cut himself very badly and he sued the people in the house and he won. Now, there are cases like that that sound crazy in the law if you don't know the whole story. So part of that story was the company that installed that window, they were careless. And they did a bad job installing it. So he was able to sue the window company and win because they legitimately were careless. What he was doing was illegal. And usually illegality would make like a contract void. But his action of climbing on their roof, he hadn't entered their house yet. And the law is very clear on this. You did not commit a crime just by thinking about it or planning on it. You didn't commit a crime until you did it. So this has actually been a huge problem in cases with battered women, because there's a bunch of cases where a woman who was very severely hurt by her husband waited until he was asleep and then attacked him or killed him. And what the court has said is he wasn't trying to hurt you at that second. And you hurt him, and therefore you're going to jail. Now, that seems unfair, and in a lot of ways it is unfair. But the law has made it very clear that until somebody commits an act, just because we cannot make thinking about things illegal or planning on things. Now, it depends how far your planning goes. Of course, if I plan to kill the president and I have a very clear plan, well, I mean, that's illegal. You know, if I plan to kill somebody, that can be illegal because that's called conspiracy. And you can conspire to do something. But still, the court needs to prove that you were really going to do it. Not that you were just, because what if I'm writing a book about it? You know, there's a TV show called How to Plan a Perfect Murder or something. That's not a crime to talk about it or plan it. It's only if you're really going to do it. So that's one side of this, is when you say there's a case where somebody defended themselves, were they in immediate threat of danger? And then there's another rule called like force. And that says, if you use fist, I can use fist. If you use knife, I can use knife. If you use gun, I can use gun. Like force. If you come at me with your fist and I pull out a knife, I'm going to jail. And it doesn't matter that I was afraid, and it doesn't matter that you attacked me first. I escalated. You came at me with a fist, I escalated to knife. So there are a bunch of cases in America where people have done things like created a spring trap, which means they connected a gun, a shotgun, to their front door with a piece of string. So when a robber came into the front door and tried to rob them, he got shot in the face with a shotgun. That's illegal. Even though he was trying to rob the house, that is not like force. And sometimes the rule of like force can be very unfair. Because what if somebody's trying to hit my mother and I grab a knife and kill them? Well, I'm protecting my mother. And I'm allowed to protect my mother. Then it would go to something called heat of passion. There are some times where we humans become animals. And if somebody attacks your mother and there's a knife right there and you just grab it, you've left being a human for a moment. You know, this is also true if you walk in and see your wife with another man or your husband with another woman in bed. It doesn't mean you're allowed to hurt them, but if you kill them when you see that, in flagrante delicto, it's called, if you hurt them when you see that, the crime is much, much lower. Because for a moment, we didn't expect you to control yourself, really. You know, if you come in and you see this, of course you're just going to, your passion is inflamed. And we understand that humans sometimes behave like animals and that's just the truth of it. That's totally off the topic of everything we're doing in this class.
But
Any other questions?
But there can be like a self-defense or something.
What can be self-defense?
If, for example, somebody big and tough than you and you're just small, you came to your place.
Sure, but I have to use like force. Just because you're a lot bigger than me doesn't mean I can grab a knife.
Sir, for example, I come to Jody's house in the night. Look at my size and Jody's size. It's not the same.
And so what should Jordy do? Grab a gun and shoot you?
Yeah, this
No.
is the only. But
No.
if not, I will kill him.
Well, you probably won't kill him. But if Jody believes that you're going to kill him, then he can kill you. Like force. However, if I get in a fight with Jordan, and Jordan's a lot bigger than me, and I think Jordan's going to hit me, I get hit. I cannot break a bottle and, you know, it doesn't matter that you're bigger than me. If I think you're going to kill me, well, then that's different. If somebody comes to you on the street and says, I have a knife, give me your money, can you take out a gun and shoot them? Not unless you can prove that you believe they were going to kill you. Otherwise, give them your money.
Yeah, like we have a lot of cases also in Saudi Arabia, like people like, you know, pull a gun on somebody and they don't shoot them. But if you shoot them, it's much like less penalty. Because like that's the reason they will know that you're not gonna kill him.
If who shoots who, it's less of a penalty than what? I don't understand.
Like for example, like somebody's wanna rob me, yeah?
Yeah.
They point a gun on me. And they leave, they didn't shoot me.
Yeah.
It's kind of like attempt of murder. But if you shoot the guy, they will know that like you didn't want to hurt him, like kill him. You just wanted to hurt him.
I'm not sure I understand.
Like
you're saying somebody robs you and doesn't shoot you.
Like for example, there's a guy is holding a gun on you. Yeah. And he doesn't shoot you.
Yeah, that's called armed robbery.
Yeah, but if he shoots you and you don't
That's called
die.
attempted murder.
No, in Saudi Arabia, it's the opposite. That's
Shooting
like
somebody cannot be armed robbery.
You mean by because like if you shoot, but you shoot his foot, you don't want to kill him. That's what you mean. Because if it doesn't, I understand.
That's assault. That's assault with a deadly weapon. And yes, assault with a deadly weapon is a different crime from armed robbery. They have different sentences.
Oh.
Yeah.
Sure, these are all different crimes. It's not automatically murder unless you tried to murder someone. Okay, let's get back. So there are two things I said I want to do. I'm going to keep you guys until 11. So I'm going to keep you guys for 45 minutes. I want to do damages and I want to do your midterm. So which first? Let's do the midterm first to make absolutely sure that we did that so you can start doing it. I haven't put the document up yet, but I will. It's done. I already have the videos up and I kept it very similar, very, very similar to the one in the videos, just for you guys to make it more reasonable so that the videos really are talking about this. So let me share my screen. Okay. Sorry. I see the problem. Okay. Did everybody see my screen?
Yes.
Okay.
Yes.
So the first thing we're going to do is first I'm just going to read this. We're just going to read it together. And then we'll talk about the tasks. There are 5 tasks. I think you need a week for each one. So here's the story. Bobby owns a small popular restaurant in Shanghai called Bad Habits. His restaurant is known for their delicious but very unhealthy food. One of their specialties is a heart attack burger. By the way, this is based on a real case. Not in Shanghai, in Las Vegas. One of their specialties is a heart attack burger, which consists of 3 hamburgers, 2 eggs, 4 slices of cheese, and a 1/4 pound of bacon. This is served with cheesy coma fries and a strawberry poison shake that has as much caffeine as 2 cups of coffee. One Wednesday, a customer named Jack came into the restaurant and ordered the heart attack meal. Jack had already consumed 5 cans of beer that day. He was also taking medicine for high blood pressure. On the wall behind the register was a large sign that read, "The management hereby gives notice that no liability is accepted for loss of any customer's possessions. Further, no liability is accepted for any injuries sustained through any services provided on these premises." Jack ordered his food, put his jacket and bag down at a table, and went to the bathroom. Meanwhile, in the kitchen, the head cook, Ashley, was preparing the order. Ashley works at Bad Habits from Friday to Sunday and works at a different restaurant from Monday to Thursday. Although she has years of experience, she's required to use the recipes and equipment provided by Bobby and to wear a Bad Habits shirt while working. Ashley receives a monthly salary from Bobby with taxes deducted. She's allowed 2 weeks holiday and 5 sick days per year. Bobby does not provide health care. Ashley has worked for Bobby for 3 years. Ashley was upset because her relationship with her boyfriend was not going well. She was thinking about what to do while text messaging her boyfriend and was not paying close attention to the food. While making the burger, she accidentally put a ½ teaspoon of pure caffeine powder into the meat instead of salt. After getting his food and returning to his seat, Jack took a bite of the hamburger. His heart started racing. He started sweating profusely and became nauseous. He sat back and his chair suddenly broke, causing him to hit his head hard on the table. An ambulance was called, and when they arrived, Jack discovered that his bag, which contained his wallet and insurance card, had been stolen while he was in the bathroom. Because of hitting his head, Jack needed to stay in the hospital for 2 days. He missed an important meeting. Jack was already on probation for drinking too much. He's very ashamed of this, as his boss had previously said that Jack was the best salesman he'd ever met, and that he had the potential to run the whole company one day. Due to his feelings of shame at missing this critical meeting, Jack quit his job and has been too depressed to look for a new job. He already turned down 2 possible interviews. Jack comes to your law office and asks you for your legal advice about his situation. Everybody understand the story so far? I know it's a long story, but
yes.
Okay. Here are the 5 things you need to do in this essay. Let's look first at B. Identify the rules that establish the tort of negligence. This is what I want you to do this week. Now, what are the rules that establish the tort of negligence? Well, we're learning them right now. There's 3 parts: duty of care, breach, damages. Duty of care has 4 tests. The first test is, the second test is, the third test is. So that's part B, is I want you to explain the law. Now for this part, let me see, I can move forward and back, yeah? Okay, for this part, let's go to task B. Here's what I want you to do. And this is what I think you should be doing this week, in addition to watching the videos. Number 1, you need a definition of negligence with a reference. Don't give me your opinion. Don't give me my words. Don't copy my PPT. Don't copy something from the internet. I need references. This is a legal paper. Number 2, explain duty of care with references. And by the way, I will put this PPT up on Blackboard. So I want references, but the references in law class are not from books. They're from court cases. Then I want breach with case law references. And that means minimum, I think you should have 2, maybe 3 for every single rule. And that's where this takes some time. Tiffany, yes?
How do we make a case reference, like
Okay,
a law paper?
I'll show you now. I'll show you now.
Paper.
I'll show you now.
Okay.
So, okay, here's what I want you to do. So first I want to know, what is a tort? A tort is, you know, a civil wrong, and that means what, you know, explain it and give me a reference. That you can get from a dictionary, like a law dictionary. What's the definition of negligence? You can get that from a dictionary or Google it, find it from a court case. then I'm giving you the answers here. Because this is not meant to be like, I'm not asking you to guess, I'm asking you to read court cases. So here we just did this. Right now, you cannot copy my language. You have to write it in your own words. So that's the challenge of me giving this to you. Now, when I say they all require case law references, that means for number one, proximity. I expect you to give me minimum like 3 different cases. Now, we already looked at some of them together on the PPT. So all of the cases that we used in class, you can use. How do you find other cases? So let me show you. Here are examples of case law references. When I say I want a case reference, here's what I'm talking about. Case reference looks like this. You have the name of the case, you have the year, and you have some numbers afterwards. Case references look like this. Never give me the internet page where you found it. I don't care. I don't care if you found it on Yahoo or Wikipedia or NOLO or Black's Law Dictionary. There's 1,000 websites. I don't care, because this case didn't come from a website. This case didn't come from a journal. This case came from court, and this is what a court reference looks like. So you have the name of the case, and usually we do it in italics. Make sure you always have this V in the middle. Then you have a year, and then you have some numbers. Now, what do you write here? I don't really care about the story. So for Donoghue v. Stevenson, this is the case where a woman drank some beer with a snail in it. If you want, you can give me a sentence or two. A woman drank beer with a snail in it and sued the manufacturer. That's enough. I definitely do not want a paragraph where you tell me once upon a time 2 women went to a cafe, and I don't care. I know. If I don't know, I'll look it up on the internet. What I want to know from you is, what's the point of this case? So the point of Donoghue v. Stevenson is to see if there's a duty of care. We look at Lord Atkins' neighbor test. That's the point. That's it. So let's say we're talking now, all this stuff we have not learned yet. Okay, damages, we'll try to learn that today. But so far we learned all of this stuff and all of this stuff. Okay, we learned duty of care and we learned breach. So, oh, it's so ugly. So I really think what you guys need to do this week is get started. Just sit down, even if you just do this part. Just get started. Please believe me, after teaching this class for 10 years, if you wait for 1 week, next week is going to be so overwhelming that you're going to, by week 3 or 4, you're just going to wait. And then the people who don't do it fail this class. So I know you can get it done, you know, just really like get started. So what you need to do is you need to look this stuff up. So let me show you now kind of what I'm talking about. Let me just share my screen. Okay, and let me get out of here. I'll discard those. Let me go to the internet. Hopefully I'll be good. I have nothing bad opened. And let's look for some cases. So let's look for maybe proximity. Oh, here's what I'm going to write. Negligence, proximity cases. So here I have some good definitions of proximity, duty of care, Wikipedia. Let's try Wikipedia. Let's try court cases.
Try YouTube.
I don't want to see things on YouTube.
Okay.
I want a list of cases. Let's try duty of care. I know I've gotten to websites before that just had lists of cases. Here's one. So with Wikipedia, duty of care, usually it'll show me other cases like this. Okay, here's a bunch of cases I could look at. Sometimes I'll just go to the bottom and just like look for other cases. You know, I'm not going to read all of this. I'm going to look around and see, can I find, okay, here's some. Home Office v. Dorset, that's a very famous case. Ans v. Merton, famous case. Here's Donoghue v. Stevenson, Headley Byrne, these are famous cases. I mean, look, I have, just going to Wikipedia, like 5 cases right here. And that's what I'm talking about. Like, the research should not be hard for you to do. You should be able to find dozens. Yeah, Ans v. Merton, obviously that's an important case. CAPARO. You know, like, I don't read all of this stuff unless I have questions about it. Generally, I'm looking for lists of cases. You know, cases are hard to read. I just want to find cases. So let's say I go to Headley Byrne. Let's see what that is. So this is a tort case, duty of care. Okay, so this is about economic loss. So this is like a damages case. Let's look for more. I think I've seen them more. Let's do negligence, duty of care, cases. Let's try list of cases. Okay, so here's an okay list with like little summaries of each one. But like, this is the kind of stuff you're gonna have to do, is just look around on the internet for a while to find different cases that stand for what I want is at least pretty much 2 cases for proximity, 2 cases for foreseeable, 2 cases for just and reasonable, 2 cases for the neighbor test, then for breach, 2 cases, at least 2. You want a better grade? Give me more. The quality of your paper has a lot to do with how many cases you find. In a good law paper, we might have a point like, you know, it would just say like the, go back to the, so in a good law paper, I might have a definition of risk of harm, and then I might have 5 different court cases afterwards. That would be a good grade. Now, if you want, give me, you know, definitely give me a sentence or 2. Tell me what the case is about in a sentence. A woman drinks beer and gets sick. A man trusts an accountant, but the books were wrong. A fire chief injured someone by putting something heavy on a truck. You know, 1 or 2 sentences. But really all I'm looking for is for you to be able to write this stuff in your own words. So I said there are 5 tasks here. Right? There are 5 tasks. This second one is just the rules. Do not talk about the facts. Do not talk about these people. Jack and Ashley and Bobby, and don't talk about them, not in B. B is nothing but the law. Is that clear?
Yes.
Okay, task B is nothing but the law. What's task C? Task C is exactly the same as B, except don't talk about the law, talk about the facts. So in task B, you're explaining what is negligence, what is duty of care, breach, and damages. So what is negligence? Then what is duty of care? 1, 2, 3, 4. And remember, proximity has 2 parts with references. Then breach, the 4 parts. And remember, risk of harm has 2 parts with references. And then damages we'll do in a minute. Then for part C, Jack versus Ashley, I just want you to use the same test. Tell me about Jack, and I mean, you could write that this week easily. Tell me about Jack and Ashley. Are they, what we just did in class, are Jack and Ashley in close physical proximity? Yes or no? Do they have a legal relationship? Yes or no? Should Ashley have foreseen that she has a responsibility to the people who eat her food? Yes or no? Why? In society, do we want a cook to have a responsibility to people who eat their food? Yes or no? Why? And then the Lord Atkins neighbor test. Was Jack directly affected by Ashley? That's it. That's C. Now, of course, there are a couple of other things, these things that we haven't learned yet, that you'll put in afterwards. But for this week, you can start writing about the story of Jack and Ashley, or you can start writing about the duty of care, breach, and damages. Is that clear?
Is that the midterm?
Yes, this is the midterm.
And not the quiz?
There is no quiz.
But there's another quiz on.
Oh, the quiz that, yeah, I still think you should do those quizzes. You want me to take away the quiz?
No, I don't know. Is it due next week?
The one for next week is due next week. Let's see, the quiz for next
the
week.
midterm.
The quiz for next week has 10 questions. You guys want me to take away the quiz and just give you the midterm for homework?
Yes.
No.
It would be good.
All right. I don't know. I could make the quiz shorter, but let's leave the quiz for next week. Okay, I need to make sure you guys understand this stuff. Torts is too important. You know, this is the whole midterm. If you guys understand this, this quiz shouldn't be that bad.
David, I have a question about the proximity.
Yeah.
So, so we have this like a physical proximity and the legal relationship. So, must be both, or must be only one of?
So that's a very good
two?
question, and that's a good question for breach also, and for duty of care also. Does the answer to all 4 questions have to be yes, 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 yes? Or could it be no to some of them? And the answer is it can be no to some of them. There's no rule that says you have to have number 1 and number 3, or you have to have 1, 2, 3, 4. The court's going to look at all of it. And sometimes the social benefit is super high, and sometimes the foreseeability is super low, and just different questions. There's no exact science to which ones have to be yes. So no, you don't need proximity sometimes. It's possible to have a duty of care even though you're not close to people, or even though you're not in a legal relationship with someone. It's possible to have a duty of care even if you didn't foresee it, or society didn't foresee it, or they weren't directly affected. It's possible.
Okay.
Any other questions? No? Okay, well, if you have questions throughout the week, WeChat me or message me. Okay, let's get back to talking about damages now. Because the more we can do with that, the closer you guys will be to being able to finish tasks 2 and 3. So we said that you need 3 things to sue someone for this case, negligence. Junpyo, what are the 3 things you need for the case of negligence?
You need the duty of care, breach, and damage.
Good. Duty of care, Junpyo, has how many tests?
You have 4 tasks.
And how many tests in breach?
4.
Good. Okay, that's where we're at so far. Now, damages. So damages are usually money when we're talking about torts. Okay, they're usually money, but not always. But the key idea in damages is there has to be a causal link. There has to be some sort of, and when I say causal, I mean cause and effect. You got hurt because of what I did. Let's say that I'm doing business with Carlotta. Okay, Carlotta, I rent bicycles. I'm a bicycle rental place. And I rent a bicycle to you. and you're riding my bicycle and the wheel falls off. So I was careless. I didn't check this bike carefully. And you fall down on the street and, you kind of like, you're okay, but you're a little nervous about hurting your arm. It's okay. It seems fine, but you decide to go to the hospital just to be careful. Okay. And at the hospital, your doctor is Dr. Aruni, and she is drunk. She is just drunk today. And she looks at you and says, oh my God, we need to get you into the operating room. And she gives you some medicine, but she gives you the wrong medicine. And you get very, very sick. And you can't go to work for the next month. Can you sue me, the guy who rented you the bicycle, for this?
No.
Well, but was I careless?
Yes.
And so I had a duty of care, and we could go through the test, but I had a duty of care to you. I broke my duty of care because I was careless. And then did you get hurt as a result of me breaking my duty of care?
Oh, yeah.
You did, but can you sue me for all of your damages for having to live in the hospital for a month?
No.
No, because I didn't cause all of that. And you can't just say, well, but David, if you didn't give me a bad bicycle, then I wouldn't be in the hospital, because some of this is Aruni's fault. And you can sue me for some of it, but you can only sue me for the part that I caused, which is you hurt your arm a little bit. That's what I caused. Because if Aruni was not drunk that day, you'd be in the hospital and out. You'd be fine. So you can't blame me for that. There has to be this idea of cause. And so in cause, we have two parts, okay? We have to have this idea of cause. That's the key idea for damages. And we call this causation. You can only get damages if your loss was caused by the defendant's breach of duty, right? Breaking the duty of care. So first we need to show that there was a duty of care. Then we need to show that someone broke the duty of care. And then we need to show that that caused your damages. Now there are two tests we have. One is called the but-for test. And the other is the foreseeable test. I said the word foreseeable is just going to come back again and again, just like reasonable. Reasonable person, rely on, foreseeable. There's some words in the law that just come back again and again and again. So let's understand the but-for test first. The but-for test asks a question. And the question is, but for the defendant breaking their duty of care, would the plaintiff have been injured? So in this question, I rented a bicycle to Aruni. But for, except for me being careless, would Aruni have gone to the hospital, Harry? Harry, except for me being careless with the bicycle, would Aruni have gone to the hospital?
Yeah.
Why did she go to the hospital?
I kind of forgot the story a little bit, but she got hurt, didn't she, in some way?
Well, that's not very helpful. Yes, she got hurt in some way. All right, let's change this example. Okay, because now I'm angry at Harry. So now, Harry, here's the example. You come to my barber shop, and I'm giving you a haircut, and I accidentally, put the wrong kind of like shampoo in your hair, and it starts burning your scalp really bad. Okay, and your hair falls out. Okay, that's what you get for not listening to my story. Now your hair is falling out. Can you sue me for that?
Yeah.
Yeah, of course. You have damage, of course. You go to the doctor. The doctor needs to give you some sort of cream or something. And, we're guys, so it's not that big a deal. Honestly, if Caitlin came to my store and all of her hair fell out, she could get a lot more money than you could. Understandably, right? Because for a woman, hair is often a much more important part of physical self-image. For a man to have your head shaved is like, maybe it's not the biggest deal in the world. A woman, you know, it tends to be more of a big deal. But nonetheless, you could certainly sue me. Now, in the same case, you go to the hospital and your doctor is a Rooney and she is just drunk. And she gives you the wrong medicine and then you get very sick. Now, could you sue me for her mistake? Well, we have two tests. The first test is called but for. Do you agree with this sentence? But for me putting the wrong thing on your head, you would not go to the hospital.
Say that again, sorry.
Except for me hurting you, you would not have gone to the hospital.
Right, yes.
If I didn't hurt you, you'd be fine.
Yes, that's true.
Right, that's true. So in that sense, that's the first test we have. And we call this the chain. Because I, by hurting you, started a chain. Now, let's say in this chain, you go to the hospital and a Rooney gives you the wrong medicine. So here, I hurt you. And now I started the chain. Now you go to the hospital and a Rooney gives you the wrong medicine and you get sick. And then you leave the hospital and on the way out of the hospital, a car hits you. And, you know, then you find out that the car was being driven by your ex-girlfriend who hates you. And so you stole a lot of money from her. And so she sues you. And then after that, you lose your job. And then after that, your parents get very sad because you lost your job. And so they decide to take a vacation. And so they decide to take a vacation. And when they're on vacation, they get robbed. And when they get robbed, they steal your mother's health insurance card. And then your mother gets sick and she can't go to the hospital and get health insurance. So she gets very sick. Can you sue me? Because I put this stuff on your hair for your mother in a foreign country getting sick.
I think so. This is like the butterfly effect, isn't it? Is it called that?
Well, I mean, I definitely caused this chain. If it wasn't for me starting this chain, none of these things would happen. But there's a really big problem with this chain. It's not my fault, Harry, that I hurt you. It's my parents' fault for having a baby. Because if my parents never had me, I wouldn't have hurt you. And it's not really my parents' fault, it's my grandparents' fault. Because if they never had a baby, they wouldn't have had my parents and they wouldn't have had me. And it's not their fault, it's really my great-grandparents' fault. And let's keep going backwards until we get here to Adam and Eve. It's all Adam and Eve's fault for having children. Because if they didn't do that, none of this would have happened and I wouldn't have hurt you.
Yeah.
And so the problem with the but-for test...
Would it be Cain?
I'm sorry? Cain?
Would it be Cain? Yeah.
I think it must have started with God, right? It's God's fault.
The hurting.
You know, so the point is there's a big problem with the but-for test. It's a very important test because it shows us, are you part of this chain? But the problem is the chain goes forever. You know, we could go forever in this direction where your mom gets hurt and your dad gets hurt and your friends get hurt and you get hurt and just, I'm responsible for everything that happens for the rest of your life. So the chain goes both directions forever. So in order to cut the chain, to stop it from going in both directions forever, we have this second test, the foreseeable test. Now, this is a little different from the one we saw in duty of care. In duty of care, I asked you, I said, is it subjective or objective? Nicola, in duty of care, is the foreseeable test subjective or objective?
In the duty of care, the foreseeable is subjective.
Good. And what question does that test ask?
If it's the duty of the negligence cause
let's use the word responsibility.
Yeah, is if the guy, if the person should know his responsibility.
Okay, good. That's fine. And that's very, very important. I want to stop sharing because this is so important, because every semester I have a lot of students who make this mistake and lose points on their midterm. So when we're talking about duty of care, the key word is responsibility. So when we talk about this foreseeability test, and it's subjective, it's asking, can you see you had a responsibility? That's it. Not can you see what would happen, just can you see you had a responsibility. This key word is responsibility. For duty of care, everything is about responsibility. So if you're a bus driver, can a bus driver see he should have a responsibility? In the case that I just showed you with this girl who's cooking this food for this guy, Jack, and she makes this hamburger, should a cook see that she has a responsibility? Not should she see what will happen. Not should she understand, or should she see if I put this powder in and he eats it, this will happen. No. Should she see she has a responsibility? That's it. For duty of care, it's just about responsibility. Now, for damages, the question is, should she see what would happen? Another way to say that, the kind of harm. Now, let's say that I get into a fight with Crystal, okay? Crystal, we're in a bar and we get into a fight. And you punch me in the arm, okay? And you don't know this. But recently, I've been very physically sick. So you punch me in the arm, and I go home, and I just, I fall asleep, and I get very ill because you punched me, and then my teeth fall out. It's part of my, I'm so anxious recently, and you punched me, and it was the first time I went out to a club in years, and I'm just so upset, and I'm so anxious, and my teeth fall out, and my hair falls out, and everything. Could you see that that kind of harm would happen?
No.
And you're not responsible for it. Could you see that my arm would hurt? And you are responsible for that. Now, it doesn't matter the extent. So there's a very famous case that we'll look at, if not today, then next time, where let's say that Crystal hits me in the arm, and Crystal doesn't know this, but I'm a hemophiliac, which means when I start bleeding, I can't stop. So you hit me in the arm and I start bleeding, or you hit me in the face and I start bleeding and I die, or I lose my arm. Did you expect me to lose my arm? No. But did you expect my arm would be hurt? You didn't know how hurt, but it's still my arm that's hurt. You're responsible even if I lost my arm. You're not responsible for something you couldn't expect, but you could have expected my arm would be hurt. You just didn't know how far. And that's an important rule called the eggshell skull, which says that we take people as we find them. If you hurt someone, you are responsible for hurting them, no matter how hurt they get, but only if you could have seen or foreseen them getting hurt this way. And that's foreseeability in damages. So again, in duty of care, foreseeability is only, can you see a responsibility? For damages, it's can you see the kind of harm? If I punch you in the face, I can see it would hurt your face. If I push you, I can see it would hurt your body. If I laugh at you, I can see it would hurt your emotions. I can see that kind of harm. But I'm only responsible for the kind of harm I could see. So let's say that I get into a fight with Harry, and I punch Harry in the arm, and then he's really angry, so he goes out and he takes some spray paint and he spray paints my name on Nicola's new Tesla car. I know, right? Can Nicola sue me? Well, let's look at, now we have two tests. The first test is the but-for test, this chain. Did I start the chain but for, except for me hitting Harry? Harry wouldn't be upset, Harry wouldn't get the paint, Harry wouldn't spray the car. Is that correct?
Yes.
So the but-for test is correct, that's true. I'm part of this chain. However, when I punched Harry's arm, could I have seen that this would lead to spray painting my name on a new Tesla? No, and I'm not responsible for that. Harry is, but I'm not. Because I couldn't have seen that kind of harm. So when we talk about damages, these are our two key tests. We have a couple minutes left. Let's look at a couple of examples of those. So, but-for test. The water in my town tastes funny. And I've been boiling it and drinking it with tea and using it to make soup. And I get these bad headaches and diarrhea, but I don't think too much about it. So one day I have really bad stomach pain and I go to the hospital and the doctor says, hey, you're going to be okay. He gives me some aspirin and sends me home. A few days later, I die of arsenic poisoning. It turns out I was not okay. The water in this town was poison. And my family sues the doctor for negligence. The doctor proves that my level of poisoning was already so serious that nothing he could have done would have helped me, and therefore he's not responsible. Is he responsible? Any
How
thoughts?
did he know that the level of poisoning?
This has been proven scientifically afterwards. They did an autopsy and looked at my blood. Florian?
I think there is a law is like you cannot leave someone or...
Okay, but I want to know negligence. I'm not asking you to tell me about other laws. I want to know about negligence, damages. We're talking about damages. We have two tests, but for and foreseeability. Can you tell me the sentence, the but for sentence in this case? But for what would happen?
Like if he didn't if he didn't act, we will still have the same effect.
Okay.
Without him.
So, can we say, except for the doctor making a bad diagnosis, I would be fine?
No, you could not.
I would not be fine.
Yeah.
Was this doctor careless? Yes, he was. But did he cause my damage? No, he did not. Understand? He's not part of the chain. I was going to die anyway, right? Even if the deceased had been examined and admitted, there was no chance that he would have been okay. Was the hospital negligent? 100%. The hospital was negligent, but they are not the cause of my damage. So we need all three tests, duty of care, breach, and damages.
David, if we have the same case, like if we go to a lawyer, so if he is aware of this law, this case, he would not like accept the case or will sue, I don't know, the water company or so on.
Yes, if you came to my office with this case, what I would probably do is I would definitely sue the water company. I would definitely sue the doctor also, because I mean, he was negligent, so I'd try to prove that maybe he's contributorily negligent, which we'll talk about next class. Maybe he's 10%, 5%. I mean, the hospital's got money. So, you know, like I want to know, because I want to sue them also, because once you sue someone, you enter discovery. And discovery is a time when lawyers can request information. So what I want to know is, are you the first person who ever came to this hospital with this problem? Or did they already know over the past months or years that people have been coming to the hospital and they never did anything about it? That they should have known that there was poisoning going on. You know, I want hospital records to check that out. So I'm going to get boxes of photocopied in. This is why court cases take years. I'm going to get boxes of information from the hospital, because what I'm also going to do is I might even go and put an advertisement in the local newspaper or internet that says, has anybody else in town had problems with the water? If so, please call David and David at whatever number and try to get them to join our suit. So then we can get some real money. Then we have a class action suit and we can sue against the water company. But sure, I'm going to sue everybody.
Okay.
You know, you always want to sue everybody you possibly can. Pretty much, as long as it's not, you know, you're not trying to use the law to hurt people. Okay, so that's a lot of information. I know I'm asking you to start this and I'm still giving you the quiz, but just look through the quiz. Here's what I'll do. I'll keep the due dates to the Wednesday following class. I won't change the due dates so that next week we can, you know, I will not take maybe the 20 minutes or something to go through it, but next week I'll say, what are the questions? And if you guys have questions about the quiz, then ask me so that you can answer it and get it in by Wednesday. Yeah, Florian?
I just have a question. What is the limit in the time for the but-for test? For example, when you start the chain, you must have a limit. As you say, you can go back to God.
So that's an interesting question. You get into something called a statute of limitations, SOL. For each kind of court case, there's a certain amount of time you have. And that's true for every case in the world except murder. Murder has no SOL. And that's why sometimes in the news, you see like an 85-year-old person who's finally caught for a murder he did 60 years ago. That's possible for murder, nothing else. So for example, for a medical case where a doctor hurt you, you have usually 5 years. You have 5 years to sue them. Now, if you're asking when did this happen, so if it happened 20 years ago and you didn't sue until today, the court's going to want to know why. You know, why'd you wait so long? So usually you have 5 years. In contracts, you usually have 10 years. I think I'm getting this right. I'll check. But I think it's 10 years for a contract, 5 years for medical cases. Different cases have different amounts of time. Rape, you know, serious crimes are 20 years. Kidnapping, arson, assault with a deadly weapon, grand theft auto, that kind of stuff is 20 years. You know, so you have a lot of time. There's no rush.
But yeah. You know, when you take all of the information, when you want to know the cause and effect, but for test, you must have a limit. Like you can take this cause and cause and cause and cause, and to get to the effect. How far? I mean, go back.
It's just more like, let's say that today I have all kinds of, you know, psychological problems, and I go see a lawyer, and it turns out that there's this whole series of things that happen, and it goes back to when I was 20 years old and you were my first doctor, and you were a terrible doctor and you gave me bad advice and bad medicine, and I had all these terrible dreams and whatever. All my problems started with you. That was 20 years ago that happened. I'm not going to be able to sue you.
Okay.
It's just too long ago. So even though you started the chain, I waited too long. We don't let people sue each other forever. We do have this limit.
But what if the effect is continued?
I mean, it happens, you know, but you have a certain amount of time. The issue is in the law, we would say you need to take responsibility. And if you are injured, you must go see a lawyer and get legal help. And if you choose not to, then what we assume is that you're doing it now because you want revenge. If you're waiting 10 years or 20 years or something to sue a doctor, it's because you want revenge. That's why you didn't do it in the past. If you actually needed the money for the hospital, you would have done it back then. Now, we'll always listen to extenuating circumstances. What if you were trapped in some situation and you just couldn't see a lawyer, or you were homeless, or you were in, you know, whatever terrible situation that you really couldn't, you were in prison. You know, there are situations that we will allow for. But for the average person, it doesn't make sense to wait 15 years and then sue a doctor or something like that, or sue for a contract. If I waited 15 years and then sued you for breach of contract for something you did 15 years ago, obviously it's revenge. Or at least that's the assumption. That's what it seems like. Okay, good. Thank you guys for staying the full 3 hours. Let me know if you have any questions or problems with the midterm. You'll see on the PPT I made, I'm making this due week 8. It's currently, this is the end of week 2. So I'm giving you guys, you know, it's starting week 3. So you have 5 weeks to do this. This is not a rush job. I'm just telling you, the sooner you can get it done, if you can follow my timeline, and as I teach you, like this week, because I just taught you this negligence stuff, you just get it started now, it's going to help you a lot. That's just my experience. Okay, I will see you guys next week. Bye.
Yeah,
Oh,
bye.
let me transfer hosting control. I'll transfer it to Florian, and then if you guys want to talk amongst yourselves or whatever, you can.
Have a good night.
I prefer to do that.
Bye.
Transfer to someone else. I have to go. I can't.
Well, now you have to transfer it to someone else because you're the host.
I don't even know how to do it.
You
Okay.
go to participants, and then you go to someone's name, and then you go to more.
No, but I think if you leave, it will
Okay,
be
guys.
automatically.
End of the class. Have a good night. See you.
Yeah, goodbye, everyone.
I can't transfer now. Okay, bye.
guys.